Good afternoon, everyone. My name is Nancy Lopez. I'm the Executive Director of the Washington Council of Lawyers, and I am so pleased to welcome you all to our third and final day of our Summer Pro Bono and Public Interest Forum. To tell you a little bit about our first panel on civil rights and civil liberties and introduce our moderator is Mark Kovner, current president of the Washington Council of Lawyers. Mark?
Thank you very much, Nancy. Welcome everyone. I appreciate the introduction and very glad you could join us today on this final day of our exciting summer forum. I'm hopeful that everyone has had, or most people at least, have had an opportunity to join in the earlier sessions and found them to be rewarding and insightful. I know that I did. As I said last week, this is a very exciting and very challenging time to be interested in pro bono. It's an exciting time because more lawyers than ever are practicing pro bono. Pro bono has really taken off as an obligation. Public interest law has taken off as an obligation in the last few decades, and we should be very proud as lawyers that we are a part of a profession that gives back to the disadvantaged in our communities. It's also a very challenging time, as most of you are, I'm sure, fully aware, because of the pandemic and because the gap between the haves and the have-nots, between the advantaged and the disadvantaged, keeps growing. And so the need is as acute as ever, and I know that need has been highlighted in the various panels we've had to date, and will be highlighted again in the exciting panels of this, our final day. So let me first introduce the moderator of our next panel being criminal law and death penalty. Maybe Brandy, are we having the civil rights and civil liberties panel first?
Yes, we are.
Okay, I got them conflated and confused in my notes. So let me introduce Brandy, the moderator of our civil rights and civil liberties panel. Brandy is legal counsel for litigation in the criminal section's human trafficking prosecution unit at the U.S. Department of Justice. And in that role, she provides legal and strategic analysis in support of the unit's enforcement activities and other initiatives. And before joining the DOJ's human trafficking prosecution unit, she worked in the department's civil rights division in the disability rights section, where she engaged in litigation, and she helped develop regulations to enforce the Americans with Disabilities Act. She is also, in her spare time, an adjunct professor at George Mason University, where she teaches courses in legal writing, legislative and regulatory drafting, appellate advocacy, and disability law. And she's in fact a graduate of the George Mason University Law School. So without further ado, let me turn this over to Brandy, who will introduce her moderators and kick off the panel.
Hi, everyone. Thank you so much for joining us today. I'm really happy that you're all here and excited to be able to hear all of our wonderful panelists who are going to come on the screen now and join us shortly. We have four excellent attorneys joining us today. And I am going to start off by allowing each of them to go around and introduce themselves by name and provide us a quick overview of what they do for their organization. So Emily, let's start with you, please.
Sure. Hi, everybody. My name is Emily Martin, and I'm Vice President for Education and Workplace Justice at the National Women's Law Center. The Law Center is based in DC, but as our name suggests, we have a national scope, and we like to say we use the law in all its forms to advocate for women and girls. I head up our work related to advocacy around workplace rights, so both civil rights to be free from sex discrimination and sexual harassment, as well as job quality related to things like increasing the minimum wage, ensuring fair work schedules, supporting the right to organize. And I also head up our work around education policy, so both around things like Title IX enforcement in schools, issues around school push out of girls of color, discipline reform, issues like that.
Thank you, Emily. Jonathan?
Good afternoon, everybody. Jonathan Smith. I'm the Executive Director of the Washington Lawyers Committee for Civil Rights and Urban Affairs. We're a regional civil rights organization. We've been around for 53 years now here in the District of Columbia. And we work on a broad range of racial equity issues in housing, employment, education. Do a lot of work in the criminal legal system reform area and a lot of work on disability rights.
Excellent. Sharon?
Hi, everyone. Thanks for having me here today for this great panel. My name is Sharon McGowan. I use she, her pronouns. I am the Chief Strategy Officer and Legal Director of Lambda Legal, which is the nation's oldest LGBT legal organization advocating for formal and lived equality for LGBTQ people and everyone living with HIV. We are headquarters in New York, but I am based out of our newest of our 6 offices in Washington, D.C. We also have offices in Atlanta, Dallas, Chicago, and Los Angeles. And we engage in a variety of legal advocacy tools. We are primarily an impact litigation organization, but engage in policy advocacy and public education on the full range of issues that are affecting LGBTQ people, not only securing new rights and bolstering rights that are under attack, but also obviously sort of defending against attempts to roll back hard fought ones of our community over the last 5 decades. So thanks for having me.
Excellent. Thanks for being here. And not least to my Civil Rights Division colleague, Taryn. Taryn, have you introduce yourself?
Yeah, I'm so happy to be here today. So my name is Taryn Wilgus-Null, and I'm a senior trial attorney at the Department of Justice in the Civil Rights Division Employment Litigation section. So in the employment litigation section, the vast majority of the work that we do is enforcing Title VII of the Civil Rights Act of 1964, which is the federal law that prohibits discrimination in the workplace. And this can be discrimination based on sex, sexual orientation, gender identity, religion, and all of our Title VII work is against state and local government employers. We also have a small portion of our work where we enforce USERRA, which is the federal law that prohibits against discrimination, workplace discrimination against veterans or active duty military. And those cases can be against, state or local government employers or private employers. So we do both, big pattern or practice cases, which are often disparate impact cases that affect, where there's, for example, a hiring practice that affects, all of the African Americans applying. We also do individual cases on behalf of, just one employee or a small group of employees. And the way that, cases come to many of our cases come to our office is through EEOC charges that are filed against state or local government employers. And if the EEOC issues cause on those charges, they then come to my office to decide whether to investigate and ultimately to litigate. So that's what we do. Very happy to be here today.
Thanks, Taryn. So for our first question, I just want to give us some first before we get into more details about pro bono, volunteer, public opportunities that current students might be interested in. I want to talk about and where we're at with the field right now. And I'm going to turn to Jonathan first with this first question. So Jonathan, where do you see kind of the public interest civil rights over the next few years, especially considering how much the field is changed due to, COVID-19 and the heightened interest in racial justice issues?
Sure. I mean, it's an interesting time to be thinking about doing civil rights work. When I started the Washington Lawyers Committee in 2016, and at that point, we all thought the election was going to come out differently. We were going to have a Supreme Court and the lower courts that were going to look very different than what we ultimately got over the last 4 years. And there was an enormous amount of optimism across the whole civil rights community and the ecosystem that advances that had been hard fought were going to be solidified and that we were going to be able to move the ball forward in very critical ways. And there's been a lot of despair over the last 4 years, but looking at what has happened at the Supreme Court, looking at what has happened at the lower courts, looking at what's happened in state legislatures and the attacks on civil rights and civil liberties around the country, it's been a really despairing last 4 years where we've been playing, really protecting what we can, preserving what we can, narrowing the harm that can be done in cases, winning some important cases. I mean, DACA was a great example of victories that you could win even in that time period. But what happened over the last year has given me sort of a renewed optimism. Nothing changed at the court, and we're not going to see our courts change. We're going to get some around the margins. There are going to be some nominations that are going to make an enormous amount of difference, but the courts are still going to be dominated by very conservative judges appointed by Donald Trump for years to come, for decades to come. But one thing that has happened with the movement that was in the streets this last year is that I think we are going to see a significant change in the way that the courts perceive these cases. One of the things that we've learned, if you look over sort of the history of transformative change through legal advocacy, whether it's advocacy in the legislature, whether it's changing the way that an agency functions, or the kinds of policy initiatives or regulations that come out of agencies, or what you see the courts do, is that they follow what happens in the street. And that the very fact that communities have risen up and have changed the conversation about the way we think about race and equity is going to have a profound effect. It may not be immediate, but it's changed the character of the conversation. And so where we can replace some of that pessimism, and mind you, the courts are not going to be sympathetic. We're not going to have lots of friends on courts. We're not going to win a lot of obvious decisions. But things like the Fourth Amendment, things like due process, things like the protection law may well have been saved by the social movement. And that social movement didn't just happen last year. It came to public fruition last year. That was the result of extraordinary organizing that's happened over decades. But I have some optimism going forward that we're not going to go back to the before time, that we're going to move forward in a very different conversation, a very different environment where the courts are going to be compelled to be responsive in a very different way.
Thank you, Jonathan. I appreciate that insight. And I wanted to kind of, similarly kick the question to Taryn as well, from like a civil rights federal perspective. Where do you see things going in the next few years and changing after the last 4 years?
Sure. Well, obviously, this is a very different administration from the last administration. So I don't know how, I think everybody knows that. I mean, in terms of what I do, the Bostock decision was so huge for us that, work that felt very, cutting edge and difficult to do very recently is all of a sudden the law of the land. The Supreme Court has said that, sexual orientation, discrimination based on sexual orientation or gender identity is sex discrimination under Title VII, full stop. And that work can just be done now. And that's phenomenal and tremendous, based on where things were just a few years ago. And I think, just to piggyback on what Jonathan said about things changing in the streets, I think we are really seeing a lot of kind of transformative change and a real change in ideas from the highest levels. And of course, those come down to the priorities in terms of, the work that federal attorneys are doing. So I think there is a lot of possibility, which is really exciting. It's an exciting time to be in the Civil Rights Division.
Yeah, absolutely. It really is. And Sharon, I'm going to kind of put you on the spot here.
I was going to say, you're welcome.
Sharon mentioned Bostock, and that obviously has changed things tremendously. And I just got a question that I actually want to pop in now, because I think it kind of relates to this idea of this question about how things are changing in the civil rights field over the next few years, especially related to Bostock and other rights for LGBTQ individuals. So I know it was just released and the questioner recognizes too, but do you have any thoughts about that came down today in Fulton?
Sure. No,
and
thanks
how
for-
and kind of how that's going to have an impact going forward.
Yeah, absolutely. And so for folks who may not have sort of all the details, sort of the snapshot is the Fulton case involved a dispute between the city of Philadelphia that engaged in contracts with a variety of service providers to help implement its child welfare system. And the dispute was about the fact that a Catholic social service agency basically did not want to have to follow the non-discrimination rules that the city of Philadelphia had put in place for anybody contracting with them in this program. And so what we had today was a 9-0 decision from the Supreme Court that focused really specifically on the contract that the city of Philadelphia had used for these kinds of relationships, and emphasized the fact that because Philadelphia had created an ability for people to seek exemptions from certain provisions of the contract or from non-discrimination requirements, the fact that they did not actually entertain the request for an exemption from the non-discrimination requirements from the Catholic service provider meant that they were not actually sort of engaging in sort of neutral application of policy. And so in many ways, this is a decision that's very similar to the Masterpiece Cake Shop case that we had a few years ago, where we saw entities really seeking to blow a massive hole into non-discrimination doctrine broadly. But what the court did here was sort of not only sort of decline that invitation, but actually very specifically leave these general non-discrimination provisions intact, but focus in on the fact that what Philadelphia had done was sort of created sort of, problems for itself by giving some sort of opportunities for, some more individualized consideration, and did not actually sort of apply that here. So what I think, it says is, the fact that all of these cases continue to kind of come forward is a sign of how emboldened the opponents of civil rights are by what has happened to the change in the courts. And so I think we're going to continue to see these kinds of attempts, whether it's in the LGBT civil rights space, whether it has to do with sort of reproductive choice. We should also note, obviously, that the Supreme Court today slapped down what was really in some ways a ridiculous sort of challenge to the Affordable Care Act, but it seemed, it's stuck at the district court level and it's stuck at the Court of Appeals because of the fact that, we've seen this kind of influence on the federal bench as a result of 4 years of Trump appointments. So I think in many ways, the tweet that I saw today was, doctrinally, today's decision was kind of a nothing burger. But I also think it's really important to sort of emphasize the fact that what continues to happen here is an assault on the ability of LGBTQ people who have a constitutional right to marry and have their families recognized and be treated equally with others, are continuing to face, attacks by entities that wield tremendous power and operate in spaces like this with a tremendous amount of influence, who are continuing to try and deny the lived equality that should follow from the formal legal equality. And so as a result, it's a disappointment for the children in the city of Philadelphia who are going to be denied access to the LGBTQ parents who this Catholic social service agency are declaring that they have a right to turn away. So that shouldn't be lost in the mix. But doctrinally, I think that we are still in a place where these key principles are continued to be intact, and we're going to continue to enforce them as robustly, as well as build that larger social support for why not only is that right as a matter of law, but it's also right with respect to what kind of a society do we want to live in. Because again, to Jonathan's point about the courts being receptive, or at least being aware of what's happening in the streets, judges are people too. And to the extent that there is sort of a general recognition of the importance of non-discrimination principles, that's in the ecosystem, that affects the pH of the water within which judges are doing their jobs.
Yeah, absolutely. And thank you for putting the into the broader context for everyone. I know that our attendees appreciated that. My next question, I'm going to start with Emily. So Emily, looking ahead, how do you see your field, that focuses on women's rights and at the Women's Law Center, how do you see your field more effectively integrating intersectionality into its work?
Yeah, I think that's a great question, and definitely a thing that the past year has turned into relief, but a question that the National Women's Law Center has really had front and center for the past several years. And I think that the women's legal movement as a whole has really been grappling with. And I think part of the answer is that while, for decades, the work has said, for example, the wage gap is way too big and it's even worse for women of color. I think that what we're seeing is some reorienting of the focus of the work. So as an example, I'll talk a little bit about the educational equity work that the Law Center does, where a big part of that work is focused very specifically on the educational experiences of Black and brown girls. So for example, we have done a few reports sort of digging deep into the experience of Black girls in DC public schools around dress codes and the ways that enforcement of dress codes become enforcement of very gendered and racialized ideas about how to be, how to appear, what your body should look like. And that isn't work that said dress codes are bad and even worse for Black girls. It was work that really focused on Black girls as the center of the story and amplified their voices, both as folks experiencing racist and sexist dress code enforcement and as the advocates themselves who had solutions for what should schools be doing instead. What does it look like for a school to have policies that respect and empower me as a student? And so I think that's one little slice, one little example of the ways that we are really trying to shift our orientation around a lot of questions, not just saying this is a problem for everybody and it's even worse for Black women and Latinas, but what is the particular experience of Black women and Latinas, and what do their voices lead us to in terms of policy solutions, and orienting the work more fundamentally in that way.
Yeah, elevating those voices is very important, and I think that's a great example. Thank you for talking about that. We see it so much with the policing of girls' bodies, but especially the policing of Black girls' bodies. So that's an important issue to focus on. Sharon, I have a similar question to you. With respect to the legal field in LGBTQ rights, I know that this has been a reoccurring issue that people keep bringing up about the intersectionality work in the LGBTQ field. How do you see your organization working to better incorporate intersectionality in its work?
And so in the course of the work that we've done recently around our 5-year strategic plan, although we always know sort of the best laid strategic plans often have to have the flexibility to respond to what's happening in the world. We have been really intentional in talking about making sure that the work that we are doing is centering the lives of those who are sort of the most marginalized and whose experience of experiencing discrimination on the basis of their LGBTQ status or because they are living with HIV is often sort of compounding other forms of discrimination that they are experiencing in their lives. And so I think that results in different areas of work that we have emphasized, with the Fulton case being a perfect example of that. We know that youth in out-of-home care settings like foster care are disproportionately sort of youth who have been rejected from their homes, who are experiencing homelessness. The rates of youth of color who are in those systems, obviously means then any barriers to placing them in permanent loving homes is going to then disproportionately sort of fall and compound the ways in which being denied sort of the access to sort of all of the other systems that are essential to success are going to compound these other forms of discrimination. But I think there have been other places as well where we've had the opportunity to really sort of step up and not only sort of act in solidarity, but bring forth sort of the LGBTQ experience in larger racial justice conversations. And so, for example, when President Trump, ex-President Trump, former President Trump, never again President Trump, issued his executive order last fall, shutting down the ability of anybody receiving federal government contracts or grantees from engaging in diversity trainings addressing white supremacy, systemic racism, gender inequities, things like that. We were one of the organizations, along with the Legal Defense Fund, that brought suit, but the perspective that we were able to bring was on behalf of LGBTQ and HIV service providers who have been on the front lines of providing COVID care, have been on the front, culturally sort of competent care, accessible care to people who have often sort of experienced discrimination and abuse at the hands of mainstream medicine, talking about how essential it is for them to be able to train their staff and to be out in the community, sort of speaking with a level of frankness and competence around these systemic, issues of inequity, and being denied and being gagged from the ability to do that was going to actually fundamentally undermine their work. And so that is a perfect example of where someone might see that executive order as not necessarily being an LGBTQ issue, but to the extent that these are all sort of issues that affect all of the different communities within which we work and of which we are members. It was one of those opportunities where we were able to come forward and I think, exercise sort of our partnership and our expertise, in a way that also sort of made sure that it was grounded as having deep implications for work within the LGBT community, as well as being a larger issue of racial and gender justice.
That kind of brings me to my next. And I throw this out to all of you, so I'll give you the chance to, volunteer who would like to take it first. But with the civil rights field, with students who are interested in getting involved in civil rights and civil liberties issues, is there any particular emerging issues or areas of law that you focus on as young attorneys? So anyone would like to take that, any advice you have for them? Sharon, you unmuted first.
The Administrative Procedures Act never looked so good after these last 4 years. So, this is one of those areas of law. People are like, the APA, like what? And I was like, we have all civil rights lawyers, I think, have become APA experts over the last 4 years. So I don't want to hog the mic, but that one I had to burst it out because it's one of those, I think, sort of undersold courses that civil rights lawyers should now consider to be sort of an essential part of preparing for a good civil rights practice.
Yeah, absolutely. I've always been an administrative nerd, and it's really been in handy the last few years. Emily?
Definitely. Yeah, I definitely agree with that. And I would also say, sort of building on some of the themes already in the conversation today about where the attacks are coming from and will continue to come. I think that there will be many fights around the use of religion to discriminate and the intersection between anti-discrimination protections and religious objections or conscience objections that aren't even grounded in religion, but are just grounded in an asserted moral belief that somebody else's behavior is wrong. I think there will be many fights around the intersection of the First Amendment and anti-discrimination protections under a theory, that harassing language is protected First Amendment speech, under a theory that anti-racist language is itself somehow discriminatory and imposing on the rights of the listener, sort of as previewed by the Donald Trump executive order and all the many state laws around critical race theory that we're seeing passing this year. I think a wide array of reverse discrimination arguments will be working their way through the courts. One of the places where I'm really engaged is around Title IX sexual harassment enforcement in schools, where respondents who've been held responsible for harassing or assaulting somebody argue that the accountability that they face amounts to sex discrimination against them as men, and they're getting wins in the courts. And I think that's both a disturbing trend in and of itself and a disturbing sort of thin edge of the wedge, where I expect to see that multiplying across other contexts. So thinking about those areas of law and the ways in which they intersect with civil rights law, I think is an important place to focus for the years to come, unfortunately.
Yeah, so just to before Jonathan pops in, so far we got students take admin law, take your First Amendment course, take courses on equal protection. And Jonathan, what do you have to add to that?
So I want to underscore what Sharon said, and she took the words out of my mouth. It is this, who knew that the Administrative Procedures Act was actually a civil rights law? Who knew? But it just turned out to be really true this last year. The other thing, I agree with everything that's been said, and I think that it's hard for me to be able to create a hierarchy of which are going to be the more important issues. There's so much going on so many fronts. There's so much assault on progress and so much opportunity that I wouldn't create a hierarchy. I would throw into the mix, though, that one of the things that there are all of these issues that are very doctrinal, or we're going to, what's going to be the scope and boundaries of rights that are going to exist, and how can we protect those and make those rights real. But one of the things that is just an enormous barrier to civil rights enforcement are these procedural doctrines that are sort of often hidden behind those doctrines is the inability of people to actually get into court. I mean, everybody today is talking about qualified immunity, but that's a battle that, and Chair will remember, when the Civil Rights Division, we used to fight the SG's office all the time about asserting qualified immunity because, it was a way to keep people out of court to even get to answer the question about whether there was a constitutional violation. Now, everybody at least talking about qualified immunity, I'm not sure everybody understands what qualified immunity actually is. But we're decades, people would think that, well, that's just a procedural doctrine. That's not a doctrine that goes to substantive rights, but that kept thousands of important cases out of court. And you see the same thing with organizational standing and institutional standing and the doctrines that are developing, what's going to happen to disparate impact and how the courts are going to address disparate impact, the way in which you can get municipal liability and the expansion of the doctrine of Monell to keep people out of courts, the assault on the ability of prisoners under the Prison Litigation Reform Act, which has been now 30-year, effort to try to keep prisoners from actually asserting their constitutional rights. And so beyond just, and I don't want to undermine the importance of the doctrine, but beyond the doctrine, the ability to actually make that doctrine meaningful in people's lives, the courts are whittling away at in a very aggressive way that is happening that is not going to make it on the front page of the New York Times. People are not going to understand it. There'll be a small handful of us. And as we fight to make sure that we bring our cases in ways that protect those doctrines and expand the ability of people to actually use the courts to remedy their problems and to make those rights meaningful, I think is going to be one of the real battles that's ahead. And it's going to be, it's sort of hard to sort of see your way out. If you'd asked me 2 years ago, what would happen with qualified immunity, I would have told you, we've been fighting about that. We filed an awful lot of briefs about why qualified immunity is crazy for a long time. We actually convinced Justice Thomas, but nobody else, oddly enough. And then all of a sudden, with the death of George Floyd and a realization that hundreds of people who were harmed at the hands of police could not get their cases resolved because of qualified immunity, we've now seen no movement on that issue.
Yep. Yeah, absolutely. It is good to highlight to students that there are those barriers that maybe that don't get talked about, that aren't, as prevalent, as prevalent or focused on in our system, like something like qualified immunity, which creates such a barrier to access the courts in the first place. So, thank you for emphasizing and pointing that out. I'd like to spend the next 10 minutes before we open it up to questions from our attendees. I want to talk a little bit more about how we can provide some advice to students who are really interested in getting involved. For my first question, I want to turn to Sharon. Some of the students, Sharon, that are really interested in this field might have to start out in big law for financial reasons, and maybe in their law school careers had to work in big law for financial reasons because couldn't take like volunteer unpaid opportunities in public interest or federal government opportunities. So for students that have to do that, but want to pivot later to public interest work or civil rights work, what advice do you have to give someone who would take that path? Especially anything that you can tell us from your own experience of starting out in a law firm?
Absolutely. So first of all, don't let anybody throw shade on you if you need to go to a firm to pay your bills or all those things. It is a real luxury, and I think the nonprofit world is trying to do a better job about creating paths to entry for people who are carrying astronomical amounts of law school debt. And many ways, it's, I think, on the law schools to continue to do a better job about sort of relieving those burdens. But I started my career after clerking at a law firm at Jenner & Block, and I did one of my summers, actually 2 of my summers at law firms, one of which actually was the summer between graduating and starting my clerkship. So I actually sort of had a couple summers to sort of try out different things. So I think what I would say, and the best advice that I got when I was sort of knowing that this was going to be the path that I was needing to take, was listening to those who were in the field that I wanted to eventually sort of land in. And they were saying, look, you know, the AmLaw 100 is not the list that you should be looking at necessarily. What you need to do is sort of be looking at the law firms that have a well-established practice of building the kinds of skills that you will need in order to be able to do this work, and also maybe are already sort of engaged in a meaningful way in the kinds of issue areas that are important to you. So there are some pro bono firms who have, are law firms that have a really strong dedication to immigration law, right? You know, and they have really strong partnerships in the LGBT space, for example, with immigration equality, or have partnered with us on other things. I, you know, went to Jenner & Block in part because I knew that that was a firm that had a very strong commitment to First Amendment work. And it just so happened that when I arrived in the summer of 2000, or the fall of 2002, Lambda had already been partnering with Jenner & Block on a cert petition in a little case that turned out to be Lawrence versus Texas. So, you know, in many ways, you know, my ability to get that initial, you know, some of that initial experience was because I had chosen a firm that I knew was a place where that kind of work might be coming in the door. And also similarly, one of the things that was helpful is you need to be able to kind of find those opportunities to get the experience that people like Jonathan and Emily and myself are sort of looking for when we are hiring people. You know, have you done, you know, any kind of sort of dispositive motions? You know, have you done any arguments, even sort of smaller arguments? You know, have you taken any depositions? So again, you know, part of this also is thinking about, you know, you being on some $5 billion case that's super sexy and in the news, but if, you know, maybe, you know, great, but if there you have equally an opportunity to work on perhaps a smaller case, because you can say I've run a discovery, and if the discovery was only 30 boxes, like all the better, right? You will have known how to run a discovery, and you don't necessarily need to be sort of engaged in big company X versus big company Y for the first 5 years of your life. And in many ways, actually, it's probably time that would be better spent picking up some other skills. So I think what I always say to people is, you know, if your nonprofit career is kind of like the, or your goals are like the lighthouse, you know, just, you know, you're going to be rowing, you know, and you're not going to get there right away, but you just kind of need to know that you have a plan about how you're getting from where you are to where you're trying to be. And it's a combination of skills. It's a combination of creating opportunities. It's a combination of making sure that you are in networks and talking and being in spaces with the people who are doing the work that you want to do. And to the extent that, you know, you can sort of have the ability to try and calibrate your law firm search with some of those factors in mind, you know, I think that there are many people who have been able, and we at Lambda, for example, have just, you know, hired a lawyer who came out of 5 years of big law practice, because in part, you know, not only were they able to develop those skills, but there was a commitment to doing the kind of pro bono work that allowed them to continue to demonstrate their substance matter or substantive interest in the subject matter area, that then resulted in them being a fantastic fit for us going forward. So don't despair, don't take shade, do what you need to do, but have a plan.
Great practical advice. And also thinking about it, starting your career early in your career with Lawrence all the way to Bostic, like, wow, what an evolution, right?
Probably should have mic dropped after Lawrence, but I've been lucky and I've continued to have some really some great success along the way. But when you have something like Lawrence pretty early in your career, it does have a little bit of a moment of like, wow, was that as good as it's going to get? You
know? For everyone, if you could just, like, you know, just take a few minutes to tell our attendees kind of what opportunities within your organization are available for them to get involved. And we'll start with Jonathan.
Great. So we're a relatively small organization. We've got just around under 20 lawyers and about 30 people on staff. But we partner all of our cases with people in firms. So if you end up in a firm, look for a lawyers committee case, please join us. It is a great opportunity for us to get to know you. On top, I agree with everything Sharon said, but on top of that, very often the best way to get known to and visible to an organization is to be one of their pro bono partners, to take a case, be involved in that case. You get to be to be known in a known quantity, and your commitment gets to be demonstrated. So that's very helpful. We are currently looking for people to sponsor for fellowships next year. So if people are graduating and you want to apply for an Equal Justice Works or a Skadden Fellowship, And please take a look at our webpage and consider applying. That is for lawyers who are entering the nonprofit community, because it's such a competitive environment. Fellowships is really the best way to get an entry-level position. Very few organizations are taking people into staff attorney or counsel jobs immediately out of law school. It's a unfortunate, problematic fact that's driven very much by the market that when you post for an attorney position, you get scores of applications from people who have been out of law school for years and have lots of experience. And so fellowships are a really good way to get into the legal services, pro bono, civil rights, legal aid kind of community. The other thing I would say is, in addition to large law firms, don't write out small law firms. I started my practice in a 2-person law firm, and we did civil rights work in Northern Virginia, and I did that for 5 years. It was a terrific experience. In that small law firm environment, you get this very intense mentoring opportunity, and you also get an enormous amount of that real experience of developing a relationship with a client who's got a problem that you can solve, and you can figure out how to use your legal skills to resolve those issues. And so I would encourage folks to not only look for the public interest opportunities in nonprofits, but look for the strong public interest opportunities in small firms that are dedicated to doing race equity or civil rights work or gender work or LGBT work, because they're out there, they're doing good work, they're an important part of the public interest infrastructure.
Yeah, excellent advice. Thank you, Jonathan. Emily, what about your organization? It is national in scope. What kind of opportunities do you have available?
Well, we also have a lot of pro bono partnerships, certainly on any case that we get involved with, including drafting amicus briefs. 90% of the time we do that with pro bono co-counsel. And so amicus briefs are a place where we are pretty much always working on one or more, and really relying on our law firm partners as full collaborators in the strategy, in the drafting, in the legal analysis. We also do some amount of representation of clients, a handful of cases, and always do that in partnership with law firms as well. Sometimes plaintiff side law firms, in large part because defense side law firms can be nervous about doing a case on the plaintiff side in an employment matter, for example, but there are exceptions, and we definitely are open to the scope of law firms if they are willing to do the work with us. And those cases are cases where we're litigating from soup to nuts, through discovery, through arguments, etc., and where again we tend to really rely heavily on our law firm partners to make that litigation go. Another thing that I want to flag, which is a little different from that sort of pro bono work, is we operate the Time's Up Legal Defense Fund and the Legal Network for Gender Equity. And among other things, what that means is we have a network of about 800 attorneys where if people are experiencing sex discrimination at work or at school or in seeking health care, we connect them with those attorneys for an initial free legal consultation. We aren't a party to that, we are just the connector. And we also definitely encourage attorneys to think about whether they can take on matters that come through the network, including sexual harassment matters that come through the Time's Up Legal Defense Fund, pro bono or low bono, since part of what we're trying to do is to make legal services as available as possible for plaintiffs in that situation, even if we can't take on the case, which in 98% of situations, we can't be the attorneys in that case. So we've been really excited to work with law firms, including big defense side law firms, who are willing to take on some matters or to take on representation of folks to, for example, advise them on how to talk about their experience of sexual harassment publicly in the press while protecting against defamation lawsuits. So that's another place where there's a lot of exciting opportunity that looks a little different from our sort of traditional pro bono, let's work together on an amicus brief sort of work.
Thank you. Thank you. A lot of good chock full of information there for our attendees. And Sharon, what about Lambda Legal? I know that they're based in New York. We got offices in DC, but what other opportunities, especially in the other parts of the country where students can get involved in the work that Lambda does?
Yeah, so we have a variety of ways for people to get involved. Obviously, sort of this the traditional sort of summer internship route, but we also are in the process of trying to sort of implement a paid internship sort of path, because again, recognizing the equity issues that go along with that, and to the extent that students have the ability to do it for credit, that's obviously sort of a great opportunity for people to do while they are in school. We do have 2 internal fellowships that we've actually recently just sort of hired for. So depending on where you are in law school, the timing may not work completely well, but we have the Tyrone Gardner Fellowship and the Renberg Fellowship that are, one is sort of in any office and the other is LA based. So again, that's sort of a place where I would encourage people to just kind of keep an eye on our website and stay in those sort of, kind of LinkedIn idealist kind of networks just to see when things come up. But similar to what Emily was talking about, to the extent that we have a cooperating attorney network for our legal help desk where we have matters that come to our attention where we don't necessarily have sort of the bandwidth to take on something that won't necessarily be an impact litigation case, but where advocacy from a lawyer may just, the letter may be the thing that helps get the case resolved. That is a great way for people to get involved. And so those are some of the examples of entry points for people who want to continue to support us. But we also have things like the Young Professionals Network and things where you are able to support Lambda and be out there as an ambassador for the work, not necessarily sort of taking on a legal case yourself, but being part of the larger public education and advocacy mission that Lambda does as well. And to the extent that you are somebody who is able to do it with the sophistication of having a legal training and are able to work with us and speaking to audiences and using sort of your networks to get the word out, we are always excited to work with people in that way as well.
Excellent, excellent. A lot of good opportunities there then. And Taryn, did you want to speak about DOJ internship opportunities? I'm also happy to as well, since I've been doing it for so long.
Yeah, I'm happy to speak about it. I mean, I think a lot of folks have probably, had some experience with USA Jobs. So I think, that is kind of the formal way to get an internship with DOJ. We always have a lot of summer interns, but I'd also really encourage folks to think about school year internships. We have fewer, but they're incredibly valuable. I get very spoiled every summer by having this, bevy of interns who are available to help us out with the work, and then they sadly all go back to school in August. So, so I think school year interns get a really great experience because the attorneys are just so excited to have you, and you're not competing with other interns for the good projects. I mean, we, like pretty much every employer out there, have, had fully remote interns for over a year now. And the Civil Rights Division is, again, like many employers now, in the process of figuring out what the post-pandemic, flexible working and remote working policies are going to be. I'm hoping that they will allow for remote internships. I don't know that yet, but that would provide a lot of opportunities for folks who aren't in DC. Just a couple other points to make with my, with my Washington Council of Lawyer board member hat on and as co-chair of the membership committee. If you care about, having a career in civil rights or civil liberties, and you want to, if you're in DC now or you'd like to be in DC after graduation, I would strongly encourage you to join the Washington Council of Lawyers, to get involved with the Washington Council of Lawyers. This is a really wonderful organization that connects, folks in private firms who care about pro bono work, folks from nonprofit organizations, and from government. It's a really fabulous network, and there's a lot of wonderful programming such as this. So I wanted to put that plug in. And I think a lot of folks probably also know that, the way to get a job with DOJ right after graduation is through the honors program. And that is, like fellowships, one of the few opportunities for a brand new attorney to, get a really exciting public interest job. And, I'd echo what Jonathan said about remembering to look at small law firms. I spent nearly 4 years at a small public interest law firm before I came to DOJ. And my firm actually had its own postgraduate fellowship, and several of them do. So think about looking at that, if you're interested in doing this work, because it is challenging to get that first job, as we all know. So just looking as broadly as you can is a good thing.
Yeah, it absolutely is very challenging. Those are some great tips there about ways to kind of get in the door. And Taryn's right. I mean, we hire in the Civil Rights Division, so many attorneys who come to us from having firms doing like plaintiff side or public interest type litigation and stuff. So that is definitely a great way to get involved. I wanted to add on a few things to what Taryn said about Civil Rights Division volunteer opportunities. I put in the chat a link to the Civil Rights Division's page on that, and it has information on all the different sections within the Civil Rights Division, how to apply for internships, when they're hiring. Taryn's correct. We do in the fall and spring, and I can bring you the good news that we are now opening students, nationwide to apply for those fall and spring opportunities, even if they're not in the DC area, that we are going to incorporate more of the virtual opportunities as well, since we do now have a very effective system in place for internships being conducted virtually. And this will allow us to open opportunities more fully for the fall and spring. The summer opportunities are very competitive, but we're always looking to have students be working for us during the fall and spring. Like Karen said, it's sad when that big bevy of summer interns leave us. So we're always looking for good interns during the school year as well. So check out that page if you're interested in Civil Rights Division opportunities. Otherwise, any question in the Q&A, and I can answer this, and anyone else that wants to pop in is like, how can undergraduate students get involved, especially if they are, looking to enter law school or the law field? Plug again for Civil Rights Division volunteer opportunities. Many of the sections within the Civil Rights Division do hire undergraduate volunteer interns, and it's the same application procedure as it is for law interns as well. So check that out, because that is a great way to kind of test out, the field and see if it's something you're really interested in. I would encourage anyone who is going to be graduating from undergrad to really consider working a few years in getting what you want to do and what you would like in terms of like maybe if the legal field is something for you. Emily?
I was just going to say quickly that the National Women's Law Center typically has summer undergrad interns supporting our communications department. So it can be a great way to sort of see how does a public interest legal organization work and what does the work look like while supporting the comm side of the shop. I think similarly, we often have undergrad interns in our development departments. So it's worth looking at the other parts of organizations like ours if you think maybe you're interested and you're trying to decide whether to go to law school or not.
We also use undergrads in our prison project in our workers' rights project. I would also encourage the folks to think about direct legal services programs as another place where undergrads are very frequently used. Both public defender programs and legal aid programs very often use undergrads as investigators. And that's a terrific opportunity experience. You get exposed to the profession, you get to see what's going on, and you get to, a lot of the best interactions with members of the community and clients. But don't, just because it's a law office, don't think that there's not space for a broad range of people who can use advocacy skills that may not be trained as lawyers.
Absolutely. Thank you, Jonathan. Now, I know we have two panelists that have to leave us right now. Our commitments at 1 o'clock. So I'm going to go ahead and kind of wrap things up for them. Obviously, if anyone else can stay behind, we appreciate it. And Mark has just come on the screen, so I'll let him go ahead and take over from here.